Good morning, everyone. As Matt mentioned, my name is Bijal Vakil. Sorry, Mark. As Mark mentioned, my name is Bijal Vakil, and I'm a partner at White & Case, and I do intellectual property. And I'm excited to be here today, not only to share our knowledge and issues with respect to SEPs with all of you, but I look forward to a heated discussion with my panelists. This has been a great panel to put together because none of us get along or see the world the same way. So I hope that all of you will find that enjoyable. So this is a hot issue. You're going to hear a lot of acronyms today, and I know it's early in the morning. So hopefully you're okay with this, and let's get started. Why are standard essential patents important? As the tech industry has grown and merged towards interoperability, we find that all of our companies that we represent out here are dealing with standard essential patents, either from a defensive posture, which is typically where I come from, or from a strategic licensing posture, which some of my other panelists deal with. So as this interoperability trend grows, standard essential patents are going to become ever more so important. Just putting on my global hat, this is a big issue around the world. We have Chinese companies that are looking to jurisdictions outside of China to address standard essential patent and FRAND issues. We have courts in the UK dealing with this issue and Germany. We also have the US policy on standard essential patents that came out in 2013. That was a joint effort from the PTO, the ITC, and other US government committees. Where that goes with our new president and his cronies, who knows? But that's certainly going to have an effect at the ITC and standard essential patents, so we want to talk about that as well. So with that introduction, let me introduce my panelist. Matt is sitting here. He is our economist who can provide a unique perspective. He is the founder and the leader of Cornerstone's offices here in Northern California. We have Asim Bansali from his new firm of Quinn, Bansali, and Lazarus, and he practices in commercial litigation and IP litigation. Next to him is Maura Reese, who is at Wilson Sonsini, who is a commercial and IP litigator. And finally, Megan Oelsek, who is at Turner Boyd, and who happens to have gone to the best law school in the world, because I went there. And she also practices in commercial litigation and IP litigation. So with that, I'm going to ask Matt to just give a brief overview from an economist perspective. How does this work?
Okay, thanks, Bijal. So I do have a different perspective, but it's a professional economics literature perspective on this question, but I've also been involved in many litigation cases as an expert witness. So I hope we're going to be able to talk about our trial experience. So economically, where this is coming from is that people across the bay at my alma mater, Berkeley, started writing a lot about technology, economics, and interoperability. And Rich Gilbert, one of my old professors, started doing some of the original writings, along with Carl Shapiro and others there, about encouraging innovation by basically writing IP licensing guidelines that make it less risky for competitors to get together and talk about things, not pricing, but talk about things like interoperability, which will ultimately benefit the consumer, which is, of course, the economist's ultimate criteria. So the modern iPhone has upwards of 250 standards in it. So this has been a very, very successful project. These licensing guidelines have encouraged collaborations technically between competitors and putting together these wonderful technologies that all interoperate so well. So very successful. And of course, being economists, we just assume that parties would agree on how to do this and everything would be fine.
If that were the case, I wouldn't have a job.
Then we wouldn't need the lawyers, I guess. But what we observed over time, of course, is that some differences of opinion did arise. And when you look at the standard-setting organizations in terms of their guidelines for disclosure, which they're the universally required disclosure in a letter of assurance, you notice a strange thing, at least to an economist, which is that, okay, these are all engineers. They don't know about pricing or value, supposedly, so they don't talk about it. And then the SSOs have typically very vague guidance as to what licensing should be. And that's where we get this term FRAND, or RAND in the United States, usually reasonable and non-discriminatory. So this is just, we empirically observe it, although it makes eminent economic sense, that if you're going to get together and cooperate in terms of having your technologies work together, you want to make sure that once a particular technology is adopted into the standard, that the leverage that gives, given the scope, oftentimes worldwide scope, and the fact that everybody's going to have that technology, is not taken advantage of unfairly. And so we have these letters of assurance with different SSOs having different language about, okay, you promise to license in the future on reasonable and non-discriminatory terms, or in Europe, also fair. So that makes sense if you want to avoid what economists call holdup, that is taking undue advantage of the new monopoly power you've been granted because of incorporation into the standard. And non-discriminatory as well, because you want to encourage downstream competition that's a level playing field for implementers. So this all fits within the rubric of the economics literature, and is in fact how SSOs typically behave. What is a little surprising to economists is that apart from the new guidance, but also previous guidance in the IEEE 80211 committees, there's nothing in the FRAND obligation which specifies anything about what is the royalty, what is its structure, what is its scope, et cetera. It's just silent.
So, Matt, I want to pause for a second there. You know, again, I'm putting on my defense hat, so I'm clearly biased, but how do you find that FRAND rate? And the reason I ask that question is the threat of an injunction, in my view, makes that discussion inherently unreasonable. And so we are always faced with an unreasonable patent holder trying to enforce their patent rights. So how does an economist figure out what is FRAND?
Well, thank you for disclosing that is a defense side point of view. Yes, that is correct. The interesting point to me, Bijal, is that up until Microsoft Motorola, there had been no consensus or way in which this was necessarily determined. This was done all, in fact, by bilateral, highly confidential negotiations, which to an economist suggests that there is a possibility of some residual taint of holdup because it's so secret and it's bilateral. And if there's a threat of injunction, especially over a standard which an implementer has to use, that's an even more powerful increase in leverage, monopoly leverage, and increase in potential value. But after eBay, you know, at least in the United States, that's less of an issue. And I do want to get into the details about how, at least in the courts, this is working its way through in terms of determining, okay, well, what is a FRAND rate? Because apart from royalty-free structures, and like in the Bluetooth Alliance, there is no specified rate in any of these letters of assurance or proceedings of the SSOs. It is, you might say, if you were suspicious, they're purposely silent. And as a matter of fact, Carl Shapiro, you might recall, when he was Assistant Attorney General, pointed out that, well, gosh, remember the IP licensing guidelines didn't mean to imply that patent holders would be colluding in any way to get hold-up rates ex post facto because they didn't sign on ex ante to a particular rate. Now, the IEEE now has propounded a new policy, partly in response to Shapiro's comments, I think, which indicated a preference to considering a smallest saleable patent practicing unit in whatever rate is eventually determined. And this is highly, highly controversial, of course. And now that we've got Macon Delrahim as the Assistant Attorney General, he's made his views very clear that his concerns are the opposite of Carl Shapiro's. His concern is that it's implementers conspiring to get lower rates than they should that a patent holder deserves. Like Carl Shapiro, he's even casually talked about going after the IEEE for that policy. Now, by the way, the 802.11 committee LOA does have a voluntary disclosure of a rate. So you can either disclose, I've got patents and I promise to be good, or you can actually put a rate down at the bottom. And we had testimony in the Innovatio case from one of the committee members that was operating at that time, Matt Shoemaker, and he said, well, nobody discloses a rate, and maybe that's strategic, maybe not. But he said one time, one party did disclose a rate. They wanted 2% for themselves, even though they had only a handful of patents out of a standard that has thousands. And so the committee said, well, thank you very much. We're not going to use your technology. These hyper-confidential bilateral monopoly negotiations have gone on for a long time. It is the most confidential business information out there, almost. Up until Microsoft Motorola, there hadn't been any determination under the law about, okay, well, what does friend mean? But now we've got a bunch of cases following Microsoft Motorola, and I just wanted to give this general introductions so we can talk about those methodologies in those cases.
Perfect. Thanks, Matt. You've confirmed for me that economists are like lawyers. The answer is it just depends.
We invented that. That's right. It does depend.
So Megan, one of the focuses of our panel is to give some practical advice to the practitioners and the companies that are represented here. And let's start off with, what practical advice do you give an in-house person about an SEP patent?
Well, to start with, when you receive a patent assertion and it looks like it may implicate a standard essential patent, it's incredibly important that a litigation practitioner is involved, whether that is an in-house litigator or for a smaller legal department, perhaps outside counsel. It's very challenging because I know a lot of large technology companies receive so many letters, so many assertions, but it really needs to be communicated out to your licensing team, to the business people, or even the business lawyers who perhaps are not patent litigation experts, that anything that comes in that may implicate a standard really needs to be taken to a litigator, and it's incredibly important that the company is very thoughtful in how they respond. To back up a little bit, when you are trying to enforce the FRAND obligation, and there will be procedures spelled out for each individual standard setting organization, but there are generally rules about the behavior of both parties in showing that there was an offer of a reasonable license, but as the licensee, it's very important that you appear to be a willing licensee, and there even may be specific procedures that would be spelled out by the standard setting organization that need to be taken. So if there is not a thoughtful response and a response that shows you are willing to take a license on the reasonable and non-discriminatory terms, that actually could be used later against you, and it may be that it would essentially let the patent holder off the hook. They could say, well, we tried to offer a license and they were not a willing licensee, so we are now not obligated to really adhere to the reasonable and non-discriminatory terms when it comes down the road in the damages phase of litigation.
So Megan, that means we can't just take those letters and throw them in the trash bin.
Exactly. But beyond that, knowing that the back and forth pre-litigation negotiations will actually become a very important part of the record if that goes to litigation, it's important that that interaction be handled with litigation in mind, and perhaps not by the licensing folks who are dealing with just an avalanche of these assertions and just trying to get as many of those off their desk as possible.
So can I add one
Sure.
very practical tip, which is I've actually been surprised at the number of times Fortune 100 companies don't have a process by which litigation or legal demand letters that might go to the CEO, which for some reason people think that's who they should address it to, or even the general counsel, where the companies don't have a process for those to get to the right person and for some kind of record to be maintained of when the document was received. So for people who are advising in-house legal departments or work there, it's kind of a simple, practical step. The other thing I've been surprised by is the number of times when you just get a letter that says, you know, we have some patents that we think are in your space. If you just send back a letter that says, thank you, we strongly respect IP rights, please provide some more information about why you think your patents are relevant to our business, you don't get a response. And so I would say for both sides, I mean, if you're asserting, if you really think this is somebody you want to pursue, then to follow up on it, but also it's not so hard to engage in response and create that record, at least in the first instance.
Asim, and just to follow up, I know this from personal experience. We get tons of these patent assertion letters. I don't know if it's one that I can just throw away or one that relates to the standard essential patent. So what is an in-house person supposed to do in that situation?
Well,
if the patent holder hasn't specified.
Well, I think in the first instance, if they haven't specified and they haven't provided claim charts, then I would say the first thing to do is just to send back a letter asking for more detail, because your goal is not at that stage, candidly, to come to the ultimate truth. It's to make a record that makes you seem reasonable. So that would be my first response. We can talk more about what you would do down the line as you get deeper into the negotiations.
Sure, thanks. And again, we want this to be iterative, so if anyone has any questions or comments, please feel free to chime in. We can take them as we go forward. Maura, my stance is not a secret. As a patent litigator, I hate to be in Texas. I hate to be in certain places. Are there jurisdictions that...
This is being recorded, Bejo,
Yes.
by the way.
I got trial in 2 weeks. But anyway, are there jurisdictions that are more favorable? I'm sorry, did you have a question?
Yeah, can I go back to Austin?
Sure.
The last point, I'm a former general counsel for many years. I don't want to send that letter back if you just told me to send back. I feel like I get a lot of these, and they're looking for something to stick, they're looking for someone to respond. I don't want to respond, I understand what you're saying, but I don't want more information. So, what I want is let it go away.
Well, and you bring up a good point, because if you get more information, maybe the damages period will start the moment that you have more notice.
Even if, for example, you get an email, or something spam, once you respond to it, now you're on the list, like, oh, this is, you answer that phone, you're on the list, and I'll call you again, and I'll come back to you. So, is there some point at which it's okay to ignore to see if they send a second letter? And is there some point at which my response is like, please give me more claims charts and more information, but more like, thank you, that's really great that you have technology. Like, what must I do with that? They haven't brought forward any particular claims or anything. I can't do anything with a letter that says they have technology.
Right. Well, I would say a couple things. First, I think there's always an exercise of judgment. I mean, if this is something that's clearly not relevant to your business, then you're probably safe ignoring it. If it looks like they've spammed, 500 companies in the same industry without really thinking about whether you practice the patent, maybe then you're safe ignoring it. On the other hand, I think there are a lot of assertion letters that come from entities that have funding and are embarking on a licensing campaign. And I mean, I'll give you one anecdotal example. I had a case where where this was an entity that, you know, had a patent that frankly didn't look that strong, but you know, had a pretty early date, and they sent a letter to one of my clients, you know, let's say in year one, and it didn't make it to the right people. After a while, it finally made it to the right people, and we had waited so long that it sort of looked odd at that point to respond. And we didn't hear from them for a while. They had been suing some other people who were using similar technologies in different industries. Then they sued, if memory serves, a different sort of one of our competitors. Eventually, about a year and a half or 2 years later, they ended up suing us. And, you know, the problem you face is that, you know, if you look at it from the perspective of an in-house litigator or even an outside litigator, it's easy to say, or general counsel, it's easy to say, yeah, I get a dozen of these a year, or maybe I get a dozen a month if you're big enough, and I can't answer them all. From a jury perspective, first of all, you're probably not going to be able to get in sort of that you get a dozen of these a month, and even if you can, then it looks like you're just using a lot of people's IP without paying for it. Yeah. So I think you have to really think about it in terms of, if this goes to litigation, how's it going to look at the end of the day? Because they will be able to argue to jurors in Texas that, you know, this big company ignored this, you know, inventor who was doing his or her best to reach out to them and, you know, strike a deal and reach a fair deal for compensation for using our invention. So again, I think it's easy to look at it, and I understand it as somebody who, you know, does a lot of defense work, from a business and litigation perspective, as this being kind of a drag and a nuisance, but you do have to think about how it's going to look at the end of the day if you're dealing with a willfulness charge, or if, in the case of Frand, you're trying to show that you were, in fact, a willing licensor, a willing licensee, which is part of one of the conditions, as we'll get into, to get some of the benefits that come from being a putative licensee of a Frand patent.
I really appreciate the question, because that is the practical challenge, and it's worth the investment to try to have a good triage process for those coming in, so that hopefully you can pick out those assertions that may be of greater importance, whether it's because this looks like it may be standards essential. They may or may not say in the letter that it is. And I would also note that unfortunately, you can't always tell based on the entity that it's coming from, because sometimes the SSO member ends up selling the patent to someone else. So, you know, it's really worth investing on the front end to make sure you have a vetting process, so you can hopefully assess which of those dozens of letters actually merit a little bit more analysis in deciding whether and when and how to respond.
Can I ask you one other question? What would you say about when a letter comes from a very large company that's known to collect the licenses portfolio? What's your response to saying? It sounds like you're talking a little bit like MPEs, but there's some large companies that are practicing.
In your example, would that large company have told you that you are violating standard essentials patents, or just patents in general?
They would probably say,
Cross.
I don't think they would say you're violating patents. They would actually say something more like, we think you might be using some of our technology, or we have some very useful patents that we'd like to discuss.
Well, if they haven't identified a specific patent, then it would be very difficult for them to establish notice. They really do need to make a somewhat specific charge of patent infringement, and at a minimum, they would need to identify a patent or patents. So if they're saying, let's start a conversation about technology without identifying particular patents that they're at least hinting that you are using, then you generally don't have to worry about a notice period starting at that point.
Do I need to respond and ask for more information, or is there some line where I can say, here you are?
That's,
So-
it's tough to have a bright
So
line
it-
test.
it-
Yeah,
right,
exactly.
it's definitely difficult to have a bright line test, and as you said, considering the source of the letter and how aggressive they're known to be, is certainly going to be part of that process that you'd want to talk over with your litigation counsel. But generally speaking, an assertion that doesn't identify a specific patent tends to be much less concerning to me, as both a litigator and someone who also does deal with the pre-litigation assertions.
Yeah, and if it's a large company that has a really big portfolio, and is more prominent, you can spend a few minutes on Google and probably find out a lot more about them and, how likely of a threat they are as compared to, an NPE with 2 patents that has a post office box in Marshall, Texas, right? So it also, the more of a threat that it might be because it's a big company with a big portfolio, possibly you could be in a position where you could get more information about it just by doing some quick research. The NPE problem tends to be, it's a really obscure entity that, you can't find
That
any
was
information
created
about.
last week before they,
But can I just add one thing? So,
If it's a large company, it's in my interest to delay. Because I want to delay the expense or delay them picking on me as a litigant with another company maybe. So, and the advisor outside counsel, like, yeah, delay is your friend, right? So, I have to decide this, right? And I have to decide, oh, there might be standards in there, or there might be something else triggered that I need to show that I'm talking to them. On the other hand, if I can ignore a couple letters until they get a little more aggressive, that might buy me like 9 months.
Sure. and-
but can I say something? Because I think, again, context matters. And the question you asked, Bijal, about does the letter talk about standards is really important. Because, as I think we all agree, if they just sort of make some general statement about, well, we have some technology that you may be using, that's kind of one kind of letter. If they say, even without identifying patents, we have patents that we believe read on, 123.456 standard, and they're a company that's known to be prominent in this field, and you work at a company, your client is one that's participated in the standard setting process with this company, that's gonna, again, I don't think that necessarily gets you into a willfulness area, but if they haven't identified the patent. But on the other hand, in terms of being a willing licensee, if they send you a letter that says, we have patents on this standard, you have engineers or sort of standards people who've participated in the body with this company, if you just ignore that letter, again, maybe ignoring the first one, maybe that's okay, just depends on the facts, but at some point, you're gonna have to engage with that company in order to be seen as a willing licensor. And if you're not a willing licensor, then you risk losing the ability to claim the benefits of the IPR policy. So again, it depends on the specific body and the specific policy, but typically that's one of the requirements, is that it be both a willing licensor and a willing licensee.
Yeah, thank you, Asim. And we'll get to that in a moment. Perhaps we should go to the earlier question from Maura, which is which jurisdictions are more favorable to whom and why?
Yeah, so in terms of jurisdictions, a lot of times, where you see these standard essential patent cases, it's the same courts in which you see patent cases generally. So quite a few of them have been filed in the Eastern District of Texas, more and more in Delaware now, especially after TC Heartland. Delaware has been getting slammed anyway. There are a number of standard essential patent cases going on in Delaware right now. California has always been a big patent jurisdiction. And as you would expect, there are also a number of standard essential patent cases going on right now. Northern District, Central District, Southern District, across California. There are a few kind of little more one-off cases, like Western District of Washington, where the Microsoft versus Motorola case was. It was a very prominent case in terms of this brand rate setting type of case. That was, I think, largely because Microsoft is located in Washington, so it's not normally seen as being that big of a patent jurisdiction. But the way these cases usually come about is that very often it's something like a counterclaim in a patent case. So somebody just files a standard patent infringement case. the patent is alleged to be a standard essential patent, and then the defendant is able to assert defenses and or counterclaims based on the standard setting policy to say, I am entitled to a license to this patent. In addition to that, sometimes you see it coming up, a case that is asserted by the potential licensee. So you see, usually these cases are going to be styled as a breach of contract. They say that the SSO's intellectual property rights policy is a contract that they can benefit from, and that it was breached because they weren't provided with a license in the way that they were required to be under the policy. The other way that this comes up in kind of the reverse situation from a licensee, sometimes you see declaratory judgments. But instead of, or perhaps in addition to, saying, I don't infringe this patent, I want a declaratory judgment of non-infringement or invalidity, they say, I want a declaratory judgment of the license that I'm entitled to. In the second situation of the declaratory judgments, the little bit trickier questions of jurisdiction. I think, as people have often seen with declaratory judgments, it's a little bit harder. You've got this extra hurdle that you have to show that there's an actual case or controversy. And that has been a controversial issue in the courts in terms of, is this a situation where the controversy has kind of ripened to a point where the court should exercise declaratory judgment jurisdiction and decide these issues for the parties. And I'll just note there was, there's right now I think many people are familiar with, there's a number of cases going on. There's a case here in the Northern District of California. The FTC has asserted against Qualcomm relating to standards essential patent issues. And then there's a lot of collateral litigation between Qualcomm and Apple, both mostly in the Southern District of California, and so all these cases are going on at the same time. But one of the really interesting things that occurred in the Southern District case between Apple and Qualcomm was that one of the claims that Apple filed against Qualcomm was seeking a declaratory judgment on patents that Qualcomm had not asserted as for infringement purposes, but Apple's claim was, well, Qualcomm hasn't asserted these in a patent infringement case, but they have notified them to a standard setting organization saying that these are potentially essential patents to these cellular standards. And Apple's argument was the fact that the patent owner has made a statement to a standard setting organization that these are potentially standard essential patents, that should be enough for a potential licensee to say that creates a controversy, I believe I'm entitled to a license, and I should be able to assert a declaratory judgment based on these claims. And the judge in that case said, looked at the declaratory judgment standard and said, I don't see enough of a patent assertion here. Qualcomm didn't directly, assert the patents against Apple. It asserted them in the context of a standard setting organization saying these are potentially essential patents. And so for in that specific case in the Southern District, the judge said, this is not a situation where there's a case or controversy where I'm going to exercise declaratory judgment jurisdiction. But these are the types of ways that these FRAND or standard essential patents issues are coming up in cases. Sometimes it's just a straight patent infringement case where you have a counterclaim raising these standard essential patent issues. Sometimes the licensee is the one who's coming into court and saying, I would like a determination about what the situation is with this patent, and am I entitled to a license, and if so, what should the terms of that license be? So it's been, these are cases that have been coming up, really across the country, but they tend to be, as you might expect, concentrated in the same jurisdictions where you ordinarily see patent cases. And I don't know in terms of, saying, one jurisdiction is more favorable to patent plaintiffs or defendants. I don't know that in the standard essential context, I would say it's really any different than you would ordinarily, the way that you would ordinarily view a jurisdiction in terms of its friendliness to either patent owners or patent defendants. My observation has been largely that it's, really the same considerations for a standard essential patent case as for any other patent case.
No, thank you, Maura. You raised the distinction between a breach of contract action and a patent case. Obviously, the patent cases go to the Federal Circuit, a breach of contract goes to the Ninth Circuit. Can you give us a little more context to that? Because that's probably a distinction that's lost on many patent practitioners.
Yeah, that's a really interesting point, is thinking about what circuit is your case going to end up in if it should be appealed. If there are patent infringement claims in the case, you're pretty much going to be in the Federal Circuit. That's a very clear basis for Federal Circuit jurisdiction on appeal. If there are not patent infringement claims and the case starts out in the complaint as a breach of contract claim, or maybe a declaratory judgment claim that's just asking for a license and that isn't asking for a determination about a substantive issue of patent law, that's a situation where more likely you're going to end up in the regional circuit. But you know, there are arguments made about whether federal circuit jurisdiction could still be appropriate, even if there isn't an actual claim for infringement of a patent in the case. The federal circuit's jurisdiction standards turn on whether there's an issue of a substantial issue of patent law that has to be necessarily decided in order to resolve the case. So I think there's interesting questions about whether you could make arguments in the context of what starts out as a breach of contract case, but one of the issues in the case, so the way this comes up is if you're going to say, I am entitled to a license to this standard essential patent, there has to be showing that it's a standard essential patent. What's a standard essential patent? Most IPR policies define a standard essential patent as a patent that's necessarily infringed by practicing the standard. So now you have an infringement issue in your case, right? Because you don't know if it's essential until you know if it's infringed. And now when you have a case where the court is deciding infringement issues, can you make an argument that, okay, now we have substantial issues of patent law in the case, this is a case that should nevertheless be appealed to the federal circuit, notwithstanding that patent infringement, under the Patent Act was not asserted as a claim in the case. So yeah, that's a very interesting issue. I haven't seen yet any of these cases asserted in state court, but I do think I could imagine someone filing a case in state court and saying, look, you could say, look, this is a breach of contract case, right? There's a contract with this, that's created by the standard setting organization's policy. Breach of contract is a very standard, state law claim. And there is a fair amount of jurisprudence out there about what happens when patent issues come up in state court cases because of things like malpractice, right? You say that the lawyer mishandled your patent case, you sue them for malpractice in state court, or a license dispute often, right? You breached the license. Well, that could end up in state court. But then you have to look at, okay, what are the issues that are raised in this case? In order to, determine the issues in this breach of license case, does the court have to look at any patent law issues? And then if you're in state court, if a patent law issue comes up in the case, you can argue, well, the federal courts have exclusive jurisdiction over issues of patent law. Maybe it's something that you can remove to federal court. But again, there's a whole body of jurisprudence about what you do when patent issues come up in state court. So I haven't seen it happen yet in the standard essential patent context. I don't know if anyone else is aware of cases that have been filed in state court, but it seems quite possible that it could be.
Interesting. Well, putting on my procedural hat, perhaps we should talk about when does a court take up whether there's a standard essential patent and whether FRAND applies in the context of a federal district court case. And at what point does the judge decide this issue?
Well, I don't think the judge necessarily decides it, and so I think the answer is often during jury deliberations. And I think more of the point you just made about the overlap between what one might call quote-unquote FRAND questions and the merits is actually quite substantial. And therefore, there's no Federal Circuit precedent, certainly, that says, oh, well, this issue or that issue is a judge issue versus a jury issue. And in fact, if you look at some of the cases that were some of the kind of what you might call preeminent cases deciding FRAND rates, there's sometimes controversy over who agreed to what, but certainly the way that those opinions describe the path to getting a bench as opposed to jury determination of those issues is they typically say, well, this is by agreement. So just last night, I went back and looked at the Inhouse case. And in the very beginning of the case, the judge says, well, the parties have agreed to have the court sort of examine the rate issue so that they can better assess the potential damages in the event liability is found, and that'll help inform potentially settlement discussions and so on. Now, again, oftentimes the path to getting there may involve sort of parties disagreeing about who agreed to what, but the reason why, I think the more important point is the reason why the courts want to put that language in there is because the judge doesn't have the authority to just reach out and grab that and say, okay, I'm going to decide this as a bench issue. Cyro versus Cisco, when Judge Davis, who's now retired, but when Judge Davis was the judge and then chief judge in the Eastern District, same thing. That was a case that ultimately he decided various issues around FRAND, including whether and to what extent the FRAND commitment applied to certain patents, and then the rates. And same thing, he says, well, this is a case, the exact words were, liability would not be argued or contested. Again, not really clear exactly how the parties got there. Those patents had been in litigation before him for some number of years prior to that. So, but he ended up trying those issues to the bench. And so I think the sort of headline out of all this, or the point coming out of this, is really that if you want the judge to take this up in some bifurcated way, it behooves you to reach agreement with the other side and of course get the court to agree, because ultimately the court has to agree, because otherwise I think in the current environment, courts are going to be hesitant to sort of bifurcate or lop off FRAND-related issues, because whether it's on the setting of the rate, whether it's around the contract issues, all of those issues have, or on essentiality, all three of those, just as examples, there's overlap with the merits, quote unquote, and under the Federal Circuit's jurisprudence, and in particular a case called Shum versus Intel, a judge can't reach out and decide through a bench trial issues that would overlap potentially with issues that a party is entitled to a jury trial on, and have those bench trial issues determined first. So in general, courts are always going to err on the side of allowing the jury trial issue to go forward first, and then either simultaneously or afterward dealing with equitable estoppel or other bench issues.
Asim, that brings up a good point, and want to ask Matt for his view. Have you seen this strange bifurcation of a case where there was a judge doing part of it and a jury doing part of it? Perhaps you could share that experience?
Yes, I have, in fact, and Microsoft Motorola is an example of that. The way it ended up being structured was that it was a bench trial in the first phase and jury trial later. And the bench trial was evidence that Judge Robart heard from us about what is a FRAND-compliant range, or RAND-compliant range. There was two standards involved in that case, Wi-Fi and then H.264.
Did the party stipulate to the judge dealing with that first part?
It is my understanding that that was why that happened that way, that the parties did stipulate for whatever reason. There might be interesting strategic questions there. But that first phase was just in front of His Honor, who made, as many of you know, a very detailed finding. And that range, which I won't be too bashful to say was my range, was a relatively modest level for the patents being requesting licensing for a variety of reasons. And then there was a second phase where the jury, on the breach question, made a comparison between the multi-billion-dollar demand letter, at least that was the implication of the demand letter, and the relatively modest handful of millions that was found to be a FRAND-compliant range. And maybe it's just coincidence, or I was asking whether bench or jury is better from the litigator's point of view, and you were saying, well, it kind of depends on if you've got an attractive witness, and that made me think, well, gosh, all my cases have been bench trials. And so, because Innovadio ended up being a bench trial, and so did TCL for whatever reason.
So Maura, when we were preparing for this conference, I disagreed with you that a jury would ever be an important factor to consider, and you seem to disagree with that, and perhaps you could give some more color to that.
Sure, yeah, I think it's just completely dependent on the facts of the case and, how you view your client's position. And I think there are some circumstances in which there are issues that you think a jury is going to be better at, and others in which you won't. And I do have a little bit of concern in this area where all these bench trials that have gone on, you're in a situation where the judge has quite a bit of discretion to make these decisions about, how am I going to decide what a FRAND rate is? And if you look at Innovadio, you look at Microsoft Motorola, you look at TCL versus Ericsson, you look at the Unwired Planet case in the UK, there's a number of these cases out there where judges in a bench trial situation have made these decisions, and they very often, come up with kind of their own personal view of, I'm going to come up with this 10-step process for determining a FRAND rate. First, we're going to do a top-down analysis of all the patents in this standard. Then we're going to then we're going to look at all the comparable licenses, and then we're going to do a step where we do an adjustment for, the worldwide patents versus a single jurisdiction. So you end up with these, kind of massively complicated, long equations, and I think that creates a certain degree of uncertainty for the parties about, what's going to be the end result of this, because judges do have so much discretion to kind of come up with their own procedure. And all of these judges in all these cases have come up with quite different procedures that they use. So from the perspective of a party, that can be a little bit concerning. Of course, juries are not known for their predictability either. So a jury, you're not going to be sitting there thinking, I know we'll have a jury trial and I'm going to have a great idea of how this is going to come out. And when you think about how complicated these cases are in terms of how difficult it is to look at all these licenses, perhaps all the patents relating to a standard, come up with some way to determine, what FRAND is in that context, it is a little bit hard to imagine, how a jury is even supposed to deal with, that huge level, that huge amount of information. And I think that you'd be in a situation where the parties would really have to work on jury instructions that are going to give very clear instructions to the jury about what they're supposed to be deciding. And then I think it would depend a lot on the experts. You'd have your economic experts, who would be.
We have an attractive one.
Yeah. So they would be giving their views, and I think the jury would probably rely a lot on the economic experts. In that situation, but it also depends on, you've taken the depositions in your case. You know what the opposing party's witnesses are like. You know if they're persuasive. You know if they seem credible or not. And that, I think, is also going to inform your view about, is the jury going to respond to this person or not? And that's also going to help you, figure out, do I want to insist on my right to a jury trial in this case, or do I want to try to reach some stipulation with the other side to do this by a bench trial?
Perfect. I believe we have a
One might
question.
argue that until recently, we had almost no guidance for jury instructions, which, ultimately, the judge obviously is going to be very involved in how those jury instructions are constructed. I will note that we do now have a model jury instruction for standard essential, for reasonable royalty in the FRAND analysis, thanks to, I think, a few folks in this room, including Professor Lemley. So the Northern District of California now has a patent damages instruction that discusses FRAND and is, I believe, the first instruction of its kind. And as we see perhaps more model instructions being written, that may increase a little bit of predictability and maybe take some of the judge-directed variability out of it. But I think that's an area that is just now beginning to really develop.
Thank you.
Could I make a brief mention from a witness's point of view about bench trials and judges? I remember we were waiting for months up in Seattle for the ruling, wondering what in the world is going on. And then this 200-page tome comes out. I mean, my gosh, where did, you know?
Those poor law clerks.
Yeah, well, I guess I guess it must be the law clerks, but it was very long and complicated. And now the champion, I guess, is Judge Burse in London, who that was 209 pages. Very, very, very complex determination. And I just want to say on the record, and apropos your earlier comment, that I like Texas, and I think Judge Gilstrap is one of the finest patent judges in the land. Certainly one of the most experienced.
That is definitely true. You had a question out there?
So you talked earlier about filing in state court and the potential ability to file breach of contract actions. So how does that tie in with the jury trial right? Because it's different in state courts and you could have equitable payment doctrines. So could you use that and maybe talk a little bit about using that as a strategy to take things away from the jury?
Yeah, I mean, I think you will, procedurally, I think that's exactly the type of analysis that you're going to do. What depending on do I want a jury or not, which jurisdiction is going to be able to better protect my right to a jury. And so I do think that, if a case gets filed in state court, you have a decision to make if you're the defendant. Is this a case that I'm comfortable being in state court, or do I want to try to find some basis to try to remove this to federal court? And I think that is one of the things that you would take into account. Procedurally for things like a jury trial and, other procedural issues, where am I better off? And I think that's, that would definitely be part of the calculus.
And just one other sort of forum-related note. So, if you have Delaware corporations, then Delaware Chancery Court, it does not, it's a non-jury forum. And the Chancery Court is where you would file for equitable relief, but it does have the ability to take on legal claims that are kind of ancillary-ish to the equitable claims. So that's a potential forum. If the core of your dispute is really, like a declaratory judgment to interpret the contract.
Yeah, and I would also just add on this state versus federal issue. One of the issues that percolates a little bit in these FRAND and standard essential patents cases is Article III jurisdiction, right? Because these cases are generally in federal court, but sometimes very often actually, you're in a situation where the potential licensee is asking the court, is saying, I would like a license, I would like the court to determine a license for me. And the Article III jurisdiction question is the existence of an injury that's sufficient to confer jurisdiction. And so the counter argument that you hear in these cases is, well, what's your injury? You don't have a license, but you haven't paid any royalties yet, so you can't say I overpaid or something like that. So what's the injury that's getting me into court? And so I think that's an issue that is, I think, below the surface in some of these cases. I think a lot of times it doesn't get raised because, the alternative to being in a limited jurisdiction court, like the federal courts where you have to meet this Article III hurdle, is state court, which is a general jurisdiction court where you don't have this bar of jurisdiction that you have to get over. And I think for these types of issues, I do think a lot of people are reluctant to be in state court. So the Article III jurisdiction issue has only tangentially been raised. Often it's sort of these declaratory judgment cases, right, where people say there's not a ripe case or controversy here. Another aspect of that is there isn't an injury here. The party that's seeking a license, especially if it's just an affirmative claim by the licensee and it's not in response to a patent infringement claim. If someone files a patent infringement claim and say, okay, I've been injured, I'm now defending a patent infringement claim, we're already in court because of the patent infringement claim, you just file a counterclaim. If the licensee wants to affirmatively come to court and say, I want a declaratory judgment, I want the court to make these determinations about what a FRAN license should be, then you get into these issues of Article III jurisdiction, declaratory judgment jurisdiction, which you might not otherwise have.
Well, let's shift gears from one scary jurisdiction, the state court, to another scary jurisdiction, the ITC. And Megan, what's your view on whether one will be subject to an injunction in the ITC if a standard essential patent is brought?
Well, due to some recent decisions, while we have not yet seen a product that was deemed to be practicing a standard essential patent actually subject to an exclusion order, Some recent cases, including the magnetic tapes investigation, number 1012, have made it pretty clear that it's really not off the table. We have not had the fact pattern quite come up. The magnetic tapes case came close, and ultimately they did not find a violation on patents that practice the standard, or in some cases the patents were found not to read on the standard. But you should not just assume that it's off the table simply because it is a standards essential patent. We did see back several years ago in certain electronic devices in the Apple-Samsung ITC investigation where a violation was found, and it was a standards essential patent, and there was a rare presidential veto, and that was under the Obama administration. The U.S. Trade Representative at that time expressed some concern about standards essential patents and hinted that maybe that's something the Commission should think about in future guidelines. But having said that, it's very tricky if you are a respondent in the ITC, because it's also been made very clear the ITC is not a forum for litigating breach of contract, and you generally are not going to be able to bring that up as a defense in the ITC. Even in the public interest aspect of the investigation, because the ITC is really constrained to their charter that is set out by statute, it's been seen from some of the comments so far that they're really not willing or able to stray from that. So you may have a situation where there may be an exclusion order even on a standards essential patent, and then later that becomes part of a subsequent contract case that would need to be brought in district court, because you really can't raise that in the ITC. If for some reason you did have a prior finding from district court, I think there was some dicta from ALJ Lord to the effect that if that had been adjudicated in a district court, it might be considered. But she declined to order the parties to take discovery on whether FRAND obligations had been met, and made it clear that was outside the scope of the ITC's jurisdiction.
So Megan, in your view, and for all the panelists, does it seem that a patent holder in the SEP context has an easier shot at the ITC? Because there's no defense that, hey, Megan, you're not licensing to me on fair and reasonable and non-discriminatory terms.
I wouldn't say that they have an easier shot there, and generally speaking, the ITC administrative law judges obviously have a great deal of patent experience, and what we've seen so far is that there has not yet been a finding that has led to an exclusion order. It seems that the ALJs generally have been somewhat conservative in whether they've been willing to find that a patent did actually read on each claim of the standard. Obviously, it's going to depend on the facts of each case and the patent and the standard involved. But certainly, I think it's something that's very much on the table, and I expect in the next few years we probably will see some further guidance on that. And this may even be an area where Congress may want to consider adding, perhaps in the public interest context, in those investigations where they make public interest part of the violation phase and authorize taking discovery on that. That's an area where this potentially could fit in, but it seems that the view of the ALJs right now is that that's not currently really part of their jurisdiction.
And do you believe that the presidential review period in an ITC proceeding might be different under our new president?
That's very difficult to predict.
Yeah.
I'll go on Twitter to find out.
Yeah, can we, so I would add just a couple points on that. I mean, one thing is, precisely because, as Megan pointed out, there are sort of limits on what the ITC can take up in terms of breach of contract. The SEP holder faces the potential for an injunctive action in federal court under, under kind of a breach of contract type theory, to keep them from going, to keep the SEP holder from going to the ITC or a foreign court potentially to get, thinking of Microsoft Motorola, to get an injunction. And so even if setting aside, I think, as Megan correctly points out, it's just hard to win an injunction finding at the ITC, and there is public interest also. I think there's also another layer, which is that the SEP holder faces the risk of a sort of a parallel action in federal court. And I think that actually ties into the original discussion about how you respond to an offer as a putative licensee, because in order to get the benefit of being able to say, I'm entitled to this FRAND royalty and therefore potentially injunctive relief against other proceedings, you have to meet your obligations under that contract, which typically mean you're a willing licensee. So, so that's what I would say, that I'm not sure the ITC is necessarily better in all respects. It is an alternative to consider.
Yeah, and I'll say I agree that historically the ITC has been very reluctant to grant exclusion orders for standard essential patents. There is the one difference is that the ITC is not subject to the eBay standard that the district courts are. So it means the ITC maybe has at least a little bit more leeway than you're going to find in a district court. Maybe somewhat more likely that you'd see some type of injunctive relief from the ITC. But again, as a practical matter, they just haven't done it. And another point on this issue of parallel actions, very often what you will see when a patent owner files an ITC case is that at the same time, on the same day, they file a parallel action in a district court, because if they want to preserve their right to damages for patent infringement, they want to have that forum where they can potentially get damages. There's a statute that allows the defendant to get an automatic stay of the district court case while the ITC case is going on. There have been circumstances where an SEP owner files for an injunction in the ITC, they file a parallel case in the district court to preserve their ability to get damages, and instead of invoking the stay that's available under the statute, the defendant proceeds simultaneously with the district court case, and then in the district court case raises their FRAND defenses, breach of contract counterclaims, things that they might not be able to raise in the ITC. And so there have been cases in which those have gone on in parallel. And so that's another strategy that defendants use, where instead of just, as a knee-jerk response saying, oh, a stay is available, I'm going to stay the district court case, parties have tried to use that parallel district court case as a forum to have those FRAND issues heard that the ITC might not hear because they're not allowed to hear counterclaims.
Although the practical difficulty is that the ITC tends to move much more quickly than most of our district courts, particularly those like Delaware, for example.
Yeah.
So depending on the jurisdiction, the ITC may well be
It's just going to outpace
finished
it.
before
Right.
it
But-
gets very far.
Yeah, and in those circumstances, you sometimes see defendants, going to the district court and saying, asking, like you said, to stay or enjoin the ITC case, or otherwise to expedite the district court case to try to get ahead of the ITC. So there's a lot of procedural maneuvering that goes on in these cases.
Well, there's an even quicker way to get an injunction. That's Germany. That's a very quick action, very little discovery. And in my experience, I am now reviewing, RAND opinions from German professors because that's going to happen before any U.S. district court case. As a matter of fact, that had happened between Microsoft and Motorola, by the way, as well, because Motorola had prevailed in Germany prior to the district court action never even getting started. By the way, they had to put up a bond.
Wow. Yeah. So this is a perfect segue into the international. Oh, I'm sorry. Go ahead.
It seems that ITC did sometimes issue order on standard essential patents. I think 5 years ago, ITC issued one against Apple.
Yeah, that's one.
But
That's correct. It was vetoed by President Obama.
is that the only thing? Okay. Standard essential
Yes, so far. Although you may want to look at the magnetic tapes case. Ultimately, an exclusion order did not issue, but there was a fair bit of discussion. That's investigation number 1012.
I know of some other potential cases, but it didn't get ruled in the favor of the patent holder. And the only reason I know about it, because there's no damages testimony at the ITC, is there is, under that statute, the ruling statute, a public interest prong. So there is an evaluation of the public interest that might serve as a basis for the trade representative to get the president to intervene. So that's a danger in that jurisdiction.
Yeah, and there was also at least one interdigital matter where some of these issues of how the ETSI commitment plays in the ITC were raised, but I don't think it ever, I think it was there was not an exclusion order that came out of that, so.
We're nearing the end of our time, so we're going to just touch upon two last subjects. The first is the international component, and as you've heard from Matt and from others, the international component is something that we certainly need to think about as our companies here in Silicon Valley have operations and substantial exposure abroad. The Unwired Planet case that you mentioned is a fun opinion to read if you have time for 209 pages. It makes for a great reading on your Kindle. Even scarier is the Huawei ZTE decision, where the court held that a very particular framework for how to address one of these demand letters. And it said that your letter that goes out needs to notify the other side that it was a standard essential patent, specify how it was infringed, and the alleged infringer must be given what those FRAND terms are and how it was calculated. And the alleged infringer is required to respond and must respond with a good faith counteroffer. And this part just gets my blood boiling. The alleged infringer needs to, as Matt pointed out, post a bond or a deposit in a bank while these negotiations are going on.
That's what gets good faith.
That is ridiculous, right? That's my view. And I'm not speaking as a European lawyer, but I mean, that is just, it's really taking this to another level. And we hope that the practical tips that we've shared with everyone here today reinforces that we need to take these issues seriously. In Europe, if you wait 12 months to respond to a letter, that's probably going to be deemed that you are not a willing licensee. The courts in Europe are going to look at, are you a big company? Are you a small company? What's the amount of resources that you have? And the larger the company you are, probably need to respond a lot sooner. There isn't much case law yet in India and China, but it seems that the literature shares with us that maybe you could have 12 months in India and China to respond to this type of assertion, but in Europe, that's just not going to fly. We have 3 minutes left, and I wanted to end on an issue that's always been perplexing for me, and I'll ask all of the panelists this question. What are the procedural and substantive ramifications when you have a patent case? Because if you're a sophisticated litigant, you will assert a standard essential patent and a non-standard essential patent. And how does that interplay work?
Well, very briefly, given our time limits, I guess. This actually is very common, especially with significant technology companies that have significant portfolios. It's an interesting strategy to assert both SEPs and non-SEPs, which might be so-called implementation patents alongside the standard. At least as far as economists are concerned, the FRAND obligation is what we call a binding constraint, right? It is actually something in addition to just a normal patent valuation damages assertion. There is this binding constraint. You promise to be fair, reasonable, and non-discriminatory, which I never got around to telling you how you determine. I guess you can call me afterwards. But the potential issue there is an interesting antitrust question of bundling. And there have been defenses like that, and it makes bringing in an antitrust perspective on this whole question is something that is likely to happen more in the future, in my view.
Asim?
So if you bring it in a litigation without sort of a prior licensing demand, then of course it's protected under Pennington just as a legal matter, although economically it may be a bundle. What I would say is that's actually one example of an instance where you as a defendant may opt for having your FRAND issues, you may prefer to have your FRAND issues decided by a jury because you can tell your whole FRAND story in a way that shades the non-essential patent as well, and that could be potentially beneficial.
Maura?
Yeah, I think that you are going to want to, try to determine pretty quickly whether, from your client's perspective, is it beneficial to have those issues tried together, or is it a situation where you might seek bifurcation? There have also been, I think, cases where patent owners have decided that it's more advantageous to file two cases, one standard essential patent case, one non-standard essential patent case. I think you saw that with TCL versus Erickson. There was that, Central District case where the standard essential patents were going on, but Erickson had also filed, I think, an Eastern District of Texas case on non-standard essential patents, and they were just on, two different tracks. So, I think it, just depends on your strategy.
Megan?
I agree. I mean, you, as a patent holder, may want to hedge your bets with two different cases, but I also agree with Asim that I think a jury is just naturally going to not compartmentalize FRAND damages versus the non-essential patent damages. The fact that you're supposed to apply different standards, I think with all of the things that a jury is going to have to sort out, particularly in a FRAND case, you will necessarily, I think, have an advantage on the non-SEP patent having had them exposed to all of the FRAND damages numbers.
Thank you. So we're feeling the heavy weight of the break and all the treats that Stanford has provided outside. So we hope that everyone learned from this presentation that standard essential patents are different. You've got to treat them differently from both perspectives. You've got to play the chessboard on jurisdictions. You've got to figure out where's going to be a good jurisdiction for you, whether you want to judge or jury, whether you're going to be defending or bringing a case in the ITC. And definitely you need an economist to help you understand what those FRAND commitments are. So thank you, Mark and Stanford, for setting this up.